Okay, so I'd just like to do a nod, first of all, to the sponsors that have sponsored this program. This is our sixth program. And
Glenn, sorry to interrupt you, but I can't see any slides.
you can't see any slides at all?
Nope.
Neither can I.
So if you're
Okay.
sharing your screen, we're not seeing it.
Yeah, here I am talking away and thinking that I'm sharing. Okay, so how's that?
Now you are. Thank you.
Yeah.
Okay, so just to reiterate what I was saying is this is our sixth cohort in English. We're starting a Spanish course, second Spanish course coming up in February, but I'd like to do a nod to our sponsors that have enabled us to keep this course as a free course. Okay. Okay, let me just scroll down. Okay, this is our contact information. Just to mention, next week's speaker, our second last speaker, is Dorothy Gordon of UNESCO. She'll be talking about social and cultural issues. And now I'd like to welcome Stephanie. So all of you probably know Stephanie very well through the ICANN circles. She did her PhD at U of T, one of the most well-versed persons I know within the ICANN space on the WHOIS issue. So I'd like to go right into it, and this is our first slide. So you tell me when you like to go to the next slide, and I'll move forward. So the session today is on name system, privacy as an example of human rights application with Dr. Stephanie Perrin. So over to you, Stephanie.
Thanks very much, Glenn. I hope you can hear me.
Yep.
Next slide, please. I've noticed that some of the presentations have been at a more global, higher level. I'd like to take a deep dive into what I would call a use case for human rights at ICANN, the Internet Corporation for Assigned Names and Numbers. I'm assuming that folks who are interested in this course have some familiarity already now with the domain name system and how it works. So I'm just going to give you a very brief look at how ICANN started and the political climate in terms of human rights and data protection when it started. Talk a little bit about the WHOIS directory and new registration data services, how it came into being, and then what it became. I want to talk a little bit about the evolution of personal information protection, how it came to be viewed as a fundamental human right, and how the law that covers data management has changed as the maturity of fundamental data protection rights has changed over the years. So, for instance, ICANN came into being in 1998. That was the deadline for European data protection law to come into some kind of conformity. So we'll talk a little bit about that, those leading cutting edge legislative movements. Then the privacy issues involved in registration, data collection, use, and disclosure. And then really, I guess, one of the things that I found interesting as I studied ICANN was the clash of policy considerations. ICANN is a multi-stakeholder experiment, I would call it. It's been going since 1998. And this is where we fight out the issues between competition, intellectual property protection, cybercrime enforcement, serious criminal law issues, consumer protection, free speech, and privacy. You'll notice how free speech and privacy come last, and that would certainly be my thesis. Anyway, the overriding question as we get into some of these more complex issues as the internet grows up and we're all on platforms, is the question of where the public interest lies and how to achieve it and how to manage that in a fractious global environment. Next slide, please.
Stephanie, Bill had a question. Go ahead, Bill.
Yeah, my sense is that the whole WHOIS system was designed and built when everybody, at least everybody running the internet, if not everybody using it, was in a country where civil rights were at least believed in, if not always followed religiously. And the problem came when we started to get a large number of countries involved where that was not really a major government consideration. Would that be an accurate?
I think it's actually complicated. The United States certainly believes in free speech and civil rights. However, they were doing their best to block data protection law in Europe throughout the 90s. And we didn't mention that I worked in the Canadian federal government for 30 years, and I spent the 90s basically going to the OECD on behalf of the Department of Industry to the Privacy and Security Committee. And certainly as ICANN came into being, the US was still fighting tooth and nail to stop the European Data Protection Directive from coming into force. And that was the first harmonizing instrument for European data protection law. The US had advanced the view that the OECD guidelines, which were voluntary guidelines, was sufficient. And that'd be fine. We're all for voluntary guidelines up in Canada too. It'd be fine if people actually followed them, but I was in government at the time, and people were sending us polite letters saying, yes, we adhere to the OECD guidelines, but they weren't doing anything to actually implement them. So that is why some of us believe that a regulatory approach to privacy protection was involved. Meantime, ICANN's being formed basically by the US government in a global dialogue with seeking global input as they basically commercialize the internet. And they stuck to this approach of basically not accepting data protection law. So maybe I'll go to the next slide. I don't know whether that opens, that answers your question. It is certainly the case that the players that were active in the internet were basically the Western democracies at that point. So we were not dealing with nation states that were trying to do surveillance on their citizens, trying to do cybercrime attacks. So I think you're partially right, Bill, but it's a bit more complicated than that.
Thank you. I didn't get into networks, let alone the internet, until sometime this century. So a lot of the history that think I know is second or third hand. So thank you for clarifying.
Yeah, and feel free to dig in again if you want more on this as we go through the slides, because I'm trying to unpack what the political climate was when ICANN was formed here. I assume folks have got the basics on internet history. At the time when, the pressure was rising for the US to commercialize the internet, governments wanted access to the tool to basically cut their costs. The 90s were a hard time for democracies all around the world. They were having trouble funding public services. And obviously, if you can put things online, you save money. You have to remember that back in the late 90s, we didn't really have the World Wide Web. We had Netscape. We had all these rather clumsy browsers at the time. And standards were evolving very quickly. Now, my second bullet here refers to the technical community structures. They were working on some of these new things, but they were hardly widespread, and people did not have the bandwidth even to get into them. So it was a kind of a chicken and egg thing where you got a bit more bandwidth. Remember the old dial-up? I can't imitate the sound, but I certainly remember. Yeah. And, so things were clumsy. I lived in the country outside Ottawa for many years, and I couldn't even run a fax machine on the telecom line I had. So, and that's in Canada. So 45 minutes from the nation's capital. Anyway, the United States had been obviously very keenly engaged in the International Telecommunications Union, which is I'm sure everybody knows, based in Geneva. That was responsible for managing the radio spectrum and the, all things space satellite. And they also managed the telecom system and the sharing of international telecom revenue. Now, that was a real sore point with the United States because they always wound up paying a bigger share of international calls. US business wanted cheap international calling. Countries that they were active in, like, I don't know, let's pick on Mexico. It took more than half of the international payments. And this was administered by the ITU, by the way, through several committees that we sent representatives to, but really contributed nothing of the technical architecture that facilitated this. So the US, that was probably not the only feature of the ITU that the US was not enamored of, but they were not keen at all on the ITU taking over, trying to regulate the internet. And so the technical community continued to manage and administer the technical pieces. So the IETF and the World Wide Web when it came into being, and the DNS, which clearly the names issue was arising, and they couldn't continue to have the precursor to VeriSign managing all of the managing and getting the income from all of the domain names. That was given to ICANN when it was created in '98 to administer as a private sector nonprofit corporation established in California. Now, of course, when something is established in California, that puts it under US law. So the next slide, please. Yeah, I think I can go to the expansion, because we're actually talking about it right now. The US issued these green and white papers from the NTIA. Becky Burr, who's still active at ICANN in many capacities, but most recently as a board member, was the, shall I say, driving force, and I think she was an assistant secretary or something at the time of the NTIA, and those green and white papers were put forward seeking input on how to establish ICANN. It was agreed to establish it as this California nonprofit in '98. WIPO and INTA were very, very active in influencing and offering comments on this process. But so were the data commissioners of the day. You will recall that I mentioned that the European directive came into force in '98. It was passed in '95. That required all European states to have data protection law that met the standard of the directive. At that time, the European Union was not centralized enough to insist on one law, one regulation for data protection, but they did not want 12 or 14 totally different laws. There was a risk that the laws would be going off in different directions and that would block data flow. The important feature of the '98 directive from the perspective of other countries was that it blocked data flow, and that data commissioners were obliged to attempt to block the data flow through their powers of data to countries that did not have adequate data protection. And the Europeans had started to review all data protection law to see whether it was adequate. And so this obviously was a bone in the throat of many countries, notably the US. And that's when the Safe Harbor Agreement came into being in, I believe, 2000. At any rate, the data commissioners were established. There was an Article 29 working group that was established by the directive itself, so that each country in Europe would name a data commissioner and put them on this committee. And that was the first effort of data commissioners to really work together collaboratively on a common approach. And they were very soon issuing annual reports and comments. And in fact, the first comments from the data commissioners were under the chairmanship of Stefano Rodotà, who was the Italian data commissioner and a very distinguished law professor. They commented on the original discussions about ICANN and the opening up of the internet. And they commented in 2000 and issued a ruling on what they saw in the WHOIS. Next slide, please. I should say a few words here about the Council of Europe Cybercrime Treaty. at the same time as the privacy issues were being resolved, the European Council of Europe, rather, had come out with their version of a code of practice, a Treaty 108, where nation states were invited to sign on to the Council of Europe Data Protection Convention, Convention 108. And in order to sign on, you had to, of course, have law in place that put these rights into effect. So the Council of Europe has been active on this since the original OECD guidelines. In fact, they were prior to the OECD guidelines. In many ways, the OECD guidelines were the non-European countries responding to the cybercrime, not to the cybercrime treaty, to the Convention 108. So that was also one of the drivers for the 95 directive, was to, you know, stay ahead of the Council of Europe's interventions. The WHOIS directory had been a kind of corner of the desk list of those who were operating the technical structures for the internet as it arose. And you have to remember that back in the 90s, it was not a commercial thing. It was a government and military and university research network. So anybody who was listed on that list, their phone number, for instance, would likely be their university or government phone number, and it was not personal. And the same thing for the domain names. They were not listed in personal, you know, in a person's name. As this opened up, of course, people were allowed to register domain names. That gets you into personal information. And that's where the problem arose. This WHOIS directory that was just really a techie's tool in the old days became a public directory containing information about all kinds of small business people, individuals, human rights organizations. I mentioned in an earlier slide that the ITU hosted the WHOIS, 2 WHOIS meetings, and then set up the IGF to sponsor dialogue among users of the internet. And that included, of course, civil rights organizations, civil society, journalists, educators, you name it. And all of those people were trying to get a website on the internet and make use of this new tool. Well, it wasn't clear at all who was doing the technical work and registering the domain name. I know when I got my names way back then in, I don't know, 2003, I asked one of my techie buddies to do it for me because this was totally arcane to me. And it was totally arcane to most people, even fairly large organizations. They didn't know how to do this. So those original names would be registered, and whoever knew how to do it and knew what a registrar was. That persists to this day. For those of us who are not knee deep in ICANN, this is arcane stuff. Anyway, the goal of WHOIS, as I say on that last bullet there, was that people should be able to find out who has registered a domain name in the event that there was abuse, or that a trade name was being abused, or that there were counterfeit goods being sold, or you know, the criminal behavior on the internet was quick to arrive. Certainly, I don't think was to the same extent as nowadays, where you open your telephone in the morning and the first 20 messages are someone telling you they want to do a business deal to transfer a few $1 billion to you. But we certainly had spam in those days, and that was one of the drivers to get the WHOIS off the less available, because it was being used by spammers to send messages. Anyway, on to the next slide, the Data Protection Directive. I think I've spoken enough about this, so we can move on to slide 7. Just a brief canned history here. We've talked a little bit about the 95 directive. Now, The folks in the European Commission who were passing the directive, that came out of the Trade and Industry branch. Not that it wasn't recognized as being human rights law, but they had the authority to do this to try to ensure the free flow of data among European states, that there would not be internal borders. So that was the sort of grounding of the 95 directive. Now, in 2000, the European Charter of Fundamental Rights, and I gave you the link there, was passed. It was not ratified until 2009. It could not be ratified really until the growing authority of the European Commission allowed it to make this a, to ratify it as the operative Charter of Fundamental Rights. So this then gave them the power to regulate the data protection. And the Charter of Fundamental Rights is important because it provides a fundamental right of Europeans to have a data protection commissioner to enforce their data protection laws, which that's an interesting thing to have in the Charter of Fundamental Rights. So I keep telling ICANN that it's not just the GDPR, as I should have said at the beginning. I was approached to be a privacy expert on the oh my gosh, Glenn, help me out. What was it called? The EWG, the expert working group that looked at the WHOIS issue back in 2013. I was asked to be that expert because I had been working, was the director of policy responsible for the work on the data protection law in Canada. And I also was the director of policy at the Privacy Commissioner's office several years later, back in 2007. So I had the background as a privacy expert. And I keep telling them, you cannot just talk about the data protection law, the GDPR. You also have to talk about the charter, because many of the cases that are brought to court are charter cases. Anyway, when the Europeans moved again they started in 2012, I believe, but it was certainly a going concern in 2014 when the EWG was arguing at ICANN about WHOIS. At that point, they had the power to pass a regulation which would bring uniformity across all of the member states. They can still pass law, but the GDPR is what applies. And in order to get over the enforcement problems where data protection law was in place, but enforcement was difficult and expensive, they enabled the data protection authorities, the DPAs, to administer fines of 4% of the gross revenues of companies. That's a pretty big hit, as you can imagine. So that got the attention of ICANN. It certainly got the attention of the registrars and registries. The GDPR came into force in 2018, and although we had made, I would say, zero progress on the RDS working group that was studying the WHOIS issue and fighting over it at the time, the registrars and registries basically delivered an ultimatum to ICANN that the contracts which required them to collect data and make it public in the WHOIS directory could not continue if they were going to be subject to 4% fines. So that was kind of what I mean, times are changing. And I'll go over the WHOIS history in the next few slides. The GDPR also brought in the ability of civil society to sue data controllers and the DPAs. This was a welcome change for those of us in civil society, because basically if a data protection controller had declined to act against a company, well, civil society could. They could take their own suit, take it to the European court, and get a fine. They don't get to keep the fine, but at least they could police the behavior. And they could sue the DPAs themselves for not acting to defend their interests. You might ask, why was this necessary? That's a whole other talk for another day. I'm writing about that at the moment. Anyway, there was also a requirement, whenever regulations come in, there's usually contract language that says that the parties have to administer all applicable law. And by the way, we're not responsible for your failure to comply. The GDPR made it very clear that data processors and data controllers were liable when something went wrong. And this forced much more scrutiny into what those contracts say. It's not actually a requirement to specify in contract according to certain terms, but best practice is leading us to that. So that this meant you couldn't just, a big company could not just say, sorry, little guy, you're responsible for all data breaches, or we don't do business with you. That was a problem under existing data protection law. So I just wanted to highlight a couple of things. Way back in 2015, a law student by the name of Max Schrems had done a project to access his data in Facebook, and he'd only been on Facebook a year or two. And when he put in his subject access request, he got, I don't know how many thousand pages, but he was absolutely stunned to see what he had. And this, of course, was all going to Facebook, and the data protection commissioners were doing nothing about the fact that his data was leaving Austria and going to the United States. So he took a case, and basically it eventually wound its way through the courts. I'm sorry, I've forgotten what year he started this, but in 2015, they heard the case and threw out the safe harbor agreement, which was the United States workaround for the fact that they had no fundamental data protection law. They had a voluntary system where companies would sign up to the safe harbor agreement, meet certain standards, and subject themselves to the FTC's administration of false advertising based powers, basically, that they committed to something, they didn't meet it, well, that's false advertising. That's how the FCC could administer fines. So that agreement got thrown out. It was immediately replaced with another one, which Schrems is now suing. So this is going to be a continuing saga, I'm sure. Up in Canada, I realize Glenn's probably the only Canadian interested in this, but we had a Spencer decision back in 2014 that was at our top court at the Supreme Court concerning access to subscriber information. And at ICANN, we fight all the time between well-meaning and very important cybercrime and security researchers and professionals who are dealing with crime on the internet. One has to remember that all of our criminal law and our Supreme Court decisions are basically defending people who are up on charges for nasty things. That's how the criminal law gets sorted. So likewise, the Spencer decision was dealing with an individual who was engaged in pornography, having an expectation of privacy in his subscriber data. So that basically stopped the police using in court any data that they had accessed without the appropriate warrant. Now, that's one of the fundamental principles behind the fight at ICANN. When ICANN made the WHOIS data publicly available and made certification of or accreditation of a registrar or a registry dependent on them providing access to that, they were basically outsourcing the responsibility for providing subscriber information to their accredited entities, the registrars and registries, the contracted parties. And going around, like a government would not be able to do that. There's a lot of delegation in government. We've actually written a research paper for the Alberta commissioner on this whole thing, where basically police can't do something, so they ask the industry to do it. And this covers everything from antique dealers dealing in stolen goods to surveillance of parking lots for stolen cars, you name it. The police find themselves in difficulties getting warrants for activities, for access to data when they don't have enough data to get the warrant. And so ICANN's publishing of the WHOIS was certainly an endeavor in that direction. However, we now have court cases that say that subscriber information cannot be regularly available, and we have the GDPR that says it can't. So, of course, we continue to argue at ICANN about whether the GDPR actually says that. I expect this to go on for years. Whether I will continue for another 9 years, I don't know. I'm beginning to get interested in other issues. Anyway, at this point in time, there are now over 120 data protection laws. I didn't put the link to Graham Greenleaf's annual survey, but if you Google Graham Greenleaf, who is a law professor in New South Wales, Australia, he has been updating an index of these laws and an assessment of them annually. So that's your go-to internet source. It's freely available.
Before we go to the next slide, I'm just curious on the Schrems case. Did this actually have to comply with the U.S. Patriot Act as well, or is that something you'll deal with it a little bit later?
Well, the U.S. Patriot Act basically allows government to do what it likes. That's irrelevant to European authorities, except that they are aware that the Patriot Act gives the U.S. powers to get in there and get data,
right?
As it does allow them to get in and get ICANN data. That reinforces the need to make sure that data doesn't go to a territory that doesn't provide adequate data protection.
Right.
Now, part of the determination of adequacy is whether there are any data protection rights afforded to foreign people, to aliens, to non-citizens. I mean, many data protection laws only protect the citizens of that country. There are certain things even in Canadian data protection law that have been a bone in the throat to an adequacy determination. For our public sector law, we have not provided access to foreign individuals, access rights. And that's largely because we have a very large quantity of immigration applications at any time. In any stage, it takes years to go through the proper channels to immigrate to Canada. And the administrative burden of managing access rights from people around the world would be crippling. So many countries, I think, have this in place. I would have to check Graham's update to see how many have changed, because Europeans provide rights for everybody. You don't have to be a citizen.
Right.
Hope that answers your question.
Yeah, that's great. Thank you. Let me just move a little bit too far.
Yeah.
Okay.
So I don't know whether I presume some people will look at this after the fact, but I don't know who's really interested in the long struggle. I was attracted to this. In fact, I moved I went back after, well, in my pre-retirement years, I went back to university to get a doctorate. I was interested in doing research on privacy enhancing technologies. I had taken a break and worked for a privacy enhancing technology, and I was aware of the struggles in actually implementing privacy enhancing technologies. Actually building privacy law into the code is quite difficult, and there'd been many failed efforts. So that was my thesis topic until I got this invitation to join ICANN on the EWG, and I was stunned. I'd seen a lot as working in the Privacy Commissioner's office, working as a consultant, working as a government person. I had been a privacy officer in the Canadian government. I'm well aware of how often privacy law is ignored, but the way ICANN was ignoring privacy law was breathtaking. So the first WHOIS committee was back in 2000. The data commissioners, through the Article 29 working group and through another technical group called the Berlin group that were looking at technical issues more. They sent their tech people to the Berlin group. They had both opined on the WHOIS database and said, you have to get this directory offline. It's, it's abusive. And I can't ignore that. So meanwhile, civil society, led by the group that I eventually joined, the non-commercial stakeholders group, they weren't called that back then, but they fought this. We invited data protection commissioners to come to ICANN and speak. I got invited myself in 2005 when I was working as the director of research at the Data Protection Office in federal one in Canada. I spoke to a privacy workshop then. That was during the combined task force in 2004 and 5. And we had a letter from our commissioner saying in no uncertain terms that this was not acceptable. Ignored. The WHOIS review team in 2010, 2012 looked at the WHOIS issues and basically wound up recommending more research into the inaccuracy of the WHOIS database and recommending more data elements. As I say, I joined the experts working group in 2013. It ran for 2 years. I had to write a dissenting opinion because even though I recognize the merits of ICANN operating a centralized system, that would be a good way to administer data protection law. The growth in the desired data elements and the I would say flimsy management of access to certain groups to get the data just it wouldn't work in a data protection regime. So then in 2015, we started with the failure of the experts working group. That was a board directed group and it wasn't a normal PDP. And I think there was already quite a bit of suspicion among members of the ICANN community as to whether that would work. Probably my dissenting report didn't help, but I can't help it as somebody who was responsible for the law that we drafted. I can't lie. So anyway, we started another group in 2015 and that lasted until the preemptive move by the registrars and registries to come up with a new RAA, what was called the temporary specification, in order to make sure they were not violating data protection law when it came into force in 2018. So the GDPR, that is. So one of the most astounding committees that I joined actually in the fall of 2014 and that prompted me to change my dissertation topic was the WHOIS Conflicts with Law group. And this basically was a procedure that a registrar who was subject to a data protection law could invoke if they felt they were violating data protection law and going to be subject to fines. But the procedure was just amazing. I mean, they had to have a notice from a data protection authority saying that they were in violation of the law, and then the legal counsel at ICANN would determine whether or not this was the case and either grant them an exemption from their WHOIS requirements or not. Well, let me tell you, I've worked in a DPA. I've worked for the European Commission on Determination of Adequacies. Once a data protection authority has done an investigation, you're lucky if you've still got your servers. They got the authority to come in and take your servers. You are in violation of the law. You are subject to fines. So you cannot put your people who you are responsible to accredit, your client base. You're managing the domain name industry, and you are going to put them in jeopardy by forcing them to violate law and get a notice that they're violating law before you let them administer the law. This is just crazy. Nevertheless, that I sat through the whole thing, and then we went into conflicts with law implementation, and nobody was listening. Anyway, another interesting group was the Privacy Proxy Services Accreditation Group, which was running 2014, 2015. In response to the lack of adherence to data protection law, many registrars and registries got around the problem, stared it down basically by providing privacy proxy services. They would put their data in the WHOIS instead of their customers, and people either paid for this or got it as a free service, but it was another source of income for the registrars. You can't really force people to pay for the fundamental right that has been guaranteed in law. So this is under threat. You better give it for free. And even if you gave it for free, the fact that ICANN is administering this regime is in violation of law. So the Privacy Proxy Services Accreditation Agreement came to what I consider to be a reasonable standoff, but it hasn't been implemented. We are stalled because of the GDPR compliance. So next slides, please. The expedited policy development process started in 2018 to try to come up with a policy that would match the temporary spec that the contracted parties forced ICANN to adopt. So I'm just flipping back to what the 2013 Registrar's Accreditation Agreement specified, because until we had a policy from the EPDP, there really was no privacy policy except for what was encapsulated in the contract between the registrars and the registries and ICANN. And these contracts are outside the policy development process at ICANN. They are considered to be the contracts between those parties, and it is not something that organizations like the non-commercial stakeholders group, to which I belong, get to have a say in. However, that was where the WHOIS policy resided. So the data delivery requirements were specified in the contract. The registrant data collection and retention requirements for law enforcement purposes. The contracted parties were required to retain data for 2 years after last contact with the registrant in case law enforcement needed access. The registrant data was to be escrowed in the US for recovery and legal issues. Now that is for the benefit of the name holder, because obviously if a company goes bankrupt and the data gets auctioned off and your name goes out of operation, you're in trouble. So this was basically a business resumption kind of procedure. But the problem was the ICANN was a party, the key party to the contract. ICANN would take it over and assign the registrants to another contracted party, but they reside in the US. And of course, that brings up the Patriot Act issues once again. The Europeans, of course, would be subject to the transporter data flow, a lack of adequacy issues, again, by sending their data to the US. So eventually, alternative arrangements were arrived at to allow data escrow with escrow providers in Europe, sooner in China, I believe. The data had to be available for bulk processing by third-party service providers like MarkMonitor and Domain Tools. It was supposed to be limited, but I don't see any enforcement action on widespread scraping. So next slide, please. In terms of the data protection issues, and there's still some controversy about this, but in my view, ICANN is a controller. It sets the requirement for the registries and registrars through these contracts. It administers the contracts. It monitors compliance. It measures accuracy. And those are all roles that are associated with controllership. At the same time, the interface with the individual is through the contracted party, through the registrar who sells them the, registers their name. It's not a sale, obviously, but for shorthand, I'll call it a sale. And so an individual would logically go to the interface that gave them their domain to access their personal data. It's important to bring up at this point that at ICANN, we debate ad nauseum the data elements that ICANN is accountable for because it's in the contracted parties agreements. In actual fact, of course, the data that is interesting to police and to law enforcement authorities generally would be all of the other data, such as the credit card data, the IP address that is the most associated with the individuals with whom they might have, online conversations about their accounts, other contact information, other services that are being sold to them, because I'm told reliably that there's no money in domain names. The money is in providing ancillary services. So web services, web development, you name it. And many of the domains that ICANN administers are sold through resellers that are supposed to meet all the requirements that the contracted parties meet. They're supposed to be administered, but ICANN does not concern itself with the actual enforcement of that data flow down. Data commissioners, on the other hand, if I were to complain about a register, they would definitely look at that. They would look at the whole package. I'm the individual. My data is in there, including my credit card data and all the rest of it. They would be concerned at what I would say the below the waterline of this particular iceberg. So while we focus at ICANN on those, top elements that were in the directory, it's a lot bigger than that. And any big class action suit that would be brought against ICANN and the domain industry would look at everything below the waterline. The purpose of the collection, use, and disclosure is unstated except for a provisional agreement that was reached in 2006. Now, we discussed the purposes in the EPDP, so we have nailed down purposes. You cannot have a purpose so broad as in the public interest, because, of course, who can define the public interest? US courts haven't been able to do it. You're looking at a very vague area there. Individuals are not informed of their rights under data protection law. There was a sort of throwaway line in the contracted parties agreements that said they should let them know, and good registrars have done that. Is there any enforcement of that by ICANN to see whether the not so good ones that don't show up at ICANN are doing it? Not that I know of. Bulk access to data is required by the agreement, except for the purposes of spam or marketing, but there's been no oversight of that. The value-added services have proliferated. For instance, domain tools, which is a key tool used by law enforcement. Next slide, please. Now, these are useful tools, don't get me wrong, but they're not in compliance with data protection law. So registrars and jurisdictions with data protection law are required to seek a waiver of these requirements, must prove they have an enforceable order. This is the WHOIS conflicts with law procedure that I discussed. That really blew me away, that one, for the purposes of my dissertation. You're basically telling people they must break the law first, they must be found guilty, and then they'll get out of applying the law. Accuracy requirements are for the purpose of law enforcement. The registrars, under data protection law, there's a data minimization requirement. You are not supposed to force going back and back to recheck the data. That's an administrative burden that you are loading onto the consumer or onto the company. And certainly in government, we're trying to get rid of administrative burdens and get rid of paperwork and cost on small business. So the accuracy requirements that ICANN has imposed are for the beneficiaries of third parties, not the contracted parties and not the registrants. The registrar really only cares about whether the bill's being paid, and they can contact the individual. And if they can do that, then their purposes have been met. This other huge sort of above the waterline group of people who benefit from access to the customer's data, well, that's a problem. The data elements include the name, address, phone, fax, and email contact. And the data retention elements include metadata, financial information, IP address, all email traffic. Now, that's the 2 years that the registrars have to keep it. That's not the escrow data. Okay, next slide, please. the contracted parties insisted on complying with the law, so they brought in the temp spec. It was good for 1 year. We set up this committee. The temp spec still applies, and the adherence to the basic principles that were in what we decided in phase 1 are in place. But we are still hemming and hawing about the disclosure model, or WHOIS replacement. This thing finally closed in September of 2020. We struck up a new EPDP phase 2A. Because basically the beneficiaries of the access did not like the way we resolved questions about the distinction between legal and natural persons and the feasibility of unique contacts. This work was completed in September of 2021, and we're waiting for a board decision. But the board did a feasibility study, a design study, and decided that it was going to be extremely costly to do this. Now, personally, I have been saying that this thing was unaffordable since I joined ICANN. I had quite a bit of experience working with our central agencies on risk management and data quality, and I have an idea what it costs to do what would be necessary to administer a central access to data engine that would be compliant with data protection law. So I'm not at all surprised that their design phase has found this thing is going to cost a lot. The position of civil society is that these costs cannot be loaded down on the individual. You cannot ask an individual to pay to have their potential adversaries in court access all their data. It's ridiculous. And unfortunately, of course, criminals get the advantage of this, but that's the way our legal system works. Criminals very often get the advantage of fundamental rights. We don't want to live in a society where we get rid of fundamental rights in order to make law enforcement cheaper. That's a Western view. So this whole argument about whether or not we're going to continue to provide a central repository that is compliant with data protection law, that's kind of coming up into a unique focus right now. It is a challenge to the multi-stakeholder model of internet governance, I think, because some people are claiming this as a failure. Personally, I don't see it as a failure. I see it as a success. It's been painful, believe me. I've been on every one of these groups, but I think it's a success. Next slide, please. So I'm going to have to skip rather rapidly through these, but I think it's one of the key things. The internet has created new costs for police forces to investigate cybercrime. And the fundamental problem is the transporter nature of it. We do not have mutual assistance agreements with all countries. There are rogue states. Let's be plain spoken about this. And so the criminals go to an area where they know they're not going to be tracked down. They cross borders to go to internet cafes. They go back across borders. It's very difficult to police cybercrime and get enforcement. The police want access to information for free. As I say, you can't download that cost to the individual whose data you're providing access to. Crime is swift, anonymous, and can leave little trace. We do have a need to bring down malware the minute it is being dispensed from a website. That can be handled by contract law. The contracted parties, have a requirement to ensure that their customers are not engaging in behavior that threatens the internet. Now, sale of rogue of ersatz handbags is not going to threaten the internet, but emitting malware does. And I believe in general there's good cooperation on bringing down sites that are emitting malware as soon as they detect it. You can suspend it, and if the people never show up again, well, fine. And they won't, because they're criminals, right? The police forces have become very reliant on private sector experts. So have the banks and other critical infrastructures in our society. In my view, as a former government person, I kind of wring my hands in despair that the governments have relegated a lot of the responsibility for malware detection and all of these cybercrime things to the private sector. So that is outside of, the rule of law and due process. So no wonder we're having this debate at ICANN. I don't fault the cybercrime researchers for wanting access to the data, but this is why we have due process, so that we can be sure that individuals have defendable human rights, and we can't just delete that by handing it over to ICANN. Governments share concerns of the private sector over trademark violation, counterfeit goods, theft of IP. I don't see a whole lot of concern from the governments who are represented at ICANN of data protection. They don't bring their data protection experts in as a general rule. There's the odd one that brings one every now and then, but it is largely intellectual property interests and law enforcement interests that comprise the GAC delegations that come to ICANN. The Cybercrime Convention was a useful instrument that, I certainly participated in back in time, but it is widely held to be too slow and heavy. Well, that's partly because governments haven't put the resources in that are required to staff it. It takes a lot of work to investigate a request for help and expedite that. And if you've only got a couple of people in your Justice Department examining these things, well, that's a slow train. Some governments do want to do surveillance of their citizens. Others are looking for drivers to permit facial recognition systems, which is a hot button with human rights defenders, because once you allow the widespread use of facial recognition systems, such as Facebook has used, then you have the ability to spot people on the street and harass them and pick them up for all kinds of things. Next slide, please. This IP and trademark owners have been active stakeholders at ICANN from the get-go. As I say, they were active in the participation in the white papers and green papers, and it's a very real issue. They're well represented by WIPO and INTA. They drive the innovation economy. They certainly drive the U.S. economy. The U.S. Government had a plan that when we performed all our trade agreements and basically the bottom fell out of the industrial worker market, they were going to base the economy on information. It became an information economy, and the U.S. has been extremely successful between the IT companies and the entertainment companies. They are the leaders, so this has worked. Fundamental to that is trademark and copyright. So this has worked well. There is a blurring of the issues. As I say, the internet, the DNS is not going to fail because somebody's selling fake Gucci bags. That is a trademark issue. The website is not ICANN's responsibility, only the domain name is. Governments have not uniformly regulated to provide accurate information on websites, and this is a consumer protection issue, but that is not an ICANN issue. The European Union has regulated to insist that websites have certain data up there. I myself find it discouraging, the number of websites when I look at something and I look to try and find out who's behind it and whether I recognize them and whether they have any bona fides. Who we are on the masthead rarely leads you to the kind of detailed information that you need. That, in my mind, is where the focus should be, but that is under national law. It is not under ICANN, and you can't make ICANN make up for what is a failure in international law. The Cybercrime Treaty was a real effort to get countries to meet decent requirements, and they're working on it all the time, but it hasn't been a great success, I have to say, because countries don't cooperate, they don't spend the money, and they won't do the enforcement. Next slide, please. The value-added services folks have made a good industry. Small players who started good apps to, monitor trademark misuse or, interesting market information about who has registered certain domain names that you might want to buy. They have made money and sold their businesses on to the giant information services. We don't necessarily hear from them often at ICANN, but those guys are the information services guys that have all data about people. They are major targets for human rights defenders because that's, you know, all governments make use of these services. That's sort of an outsourced information source that they would not be allowed to compile themselves under their legislation. So I'm talking about, you know, the big guys like Reuters, Thomson, the ones that have consolidated some of the programs that have grown up to monitor domain names. Next slide, please. I think I've talked enough about the outsourcing of criminal law to the cybercrime investigators. They don't have access to subpoenas. These guys do not have delegated authority. And so they have to use civil law procedures, which are weak in this respect. They're in the same boat as the IP folks. I apologize for my dog whining. He would like out. So they're natural allies in this discussion. Their status under data protection law is pretty nebulous, I would say. Now, data protection commissioners do not, as a rule, hound those who are performing public service, you know, but I foresee that there is sooner or later going to be a confrontation here.
Sure.
These folks are represented generally at ICANN by the Security and Stability Advisory Committee. And there's a number of the groups that maintain blacklists, for lack of a better word. APWG, there's many of them, many are proprietary. And those guys themselves only share data with their members and their allies. So it's, you know, that's an odd kind of enforcement mechanism itself. Although the same can be said of governments. Governments do not share data with governments they don't trust. Next slide, please. The registrars and registries are the hapless guys who are trying to make a buck here, in my view, and they have the direct relationship with the customers, or they have the mediated one through their resellers. It's a low margin business. They can't spend time processing complex requests for data. I have been impressed with the amount of work they go to actually evaluate these requests that are coming in. And it seems to me that it's compliant with my expectations as a former senior official in a data protection office. And of course, they're now on the hook for these fines of 4%. In my view, if it ever went to court, ICANN would certainly be dragged in and have to share that fine, but nobody wants a fine. The end users, next slide, please. And this is where there's a little bit of a challenge between, shall we say, disagreement between representatives of the end users at ICANN. ALAC represents end users at ICANN, and that includes business, commercial, governments, municipalities, individuals, you know, all kinds of people register, people and organizations register domain names. The non-commercial stakeholder group represents non-commercials. So that's average citizens, human rights groups, you know, anyone who's not engaged in commercial activity. That would include, of course, free speech and human rights advocates. They can also be members of ALAC. We have not agreed on the EPDP activities or the RDS activities because ALAC has basically backed law enforcement and IP interests in terms of such issues as differentiation between non-commercial and commercial users. The claim being, of course, if you are a commercial entity, a legal person, then you are not entitled to protection under data protection law, so your data should go out. That's the argument. Now, I volunteer for a few NGOs rather. They're big organizations. They have humans registering their domain names, all kinds of them. and therefore they're entitled to protection under data protection law. We also represent human rights organizations who are going to be harassed and their members will be tracked down and killed. So those people need protection from disclosure under human rights law. You know, this is a distinction that we feel is far too difficult for the registrars and registries to be forced to make, you know, and asking people to testify and loading that burden onto the individual or the end user won't stand up in court. I'm sure it won't. You know, it's too difficult. So, you know, there's one of the things that we have disagreed with in terms of the EPDP. So we continue to fight for a free and open internet, and that is often in conflict because, you know, you want free speech, you want access to information, but you also want protection of privacy. So that is a balance that we're rather used to. And with the focus recently in internet governance, this isn't my topic today, but this focus on getting rid of inaccurate data and hate speech, where we can see that the, you know, a lot of the stakeholders who fight for freedom of speech are not going to be in favor of policing hate speech, because there's a very fine line. We can't ban words. So for instance, I use the word blacklist. That is not an appropriate word to use in Canada these days because of the concern about the use of the word black as a pejorative. Well, there's an awful lot of words that come in that category, and this is where the free speech people are going to be, you know, having to come out on one side or the other in terms of harassment and hate speech. This is not assisted by the assault on our capital that is going on as I speak to you today from the truckers' convoy fighting for freedom. Anyway, next slide, please. Among the proposed solutions, and I'm trusting you're going to cut me off when I'm talking too long, Glenn, but otherwise I'll just continue through the next 3 slides. The purpose of the RDS data collection, use, and disclosure has to match the narrow ICANN remit. And I've talked about, there's been a lot of floating of the public interest purpose, and you know what actually is our purpose. That would permit ICANN to expand into other areas, and ICANN has a narrow remit, just the DNS, the technical and the names, not, for instance, website behavior. Public safety actors and private sector security firms, they want the easy access to public data, easy public access. But is that a purpose of registration data collection? Some would argue that it is. I would argue that it isn't. I think I've talked a bit about this. The PICs, the public interest commitments that are voluntarily being undertaken by some of the new GTLDs. We in NCSG are concerned about these PICs because that is kind of a coercion. You can get the name if you agree to the following voluntary activities. This is rather like the outsourcing that I spoke about, where governments say, yeah, you can get a license as an antique dealer, but you have to tell us when we come and ask you about stolen goods. You know, does this work? What kind of public interest commitments are they agreeing to? If it includes the suppression of speech or intrusive vetting of personal data, well, that's a problem. And that policy requirement is coming from ICANN. So ICANN is still accountable, in our view, for forcing that public interest commitment. In terms of, you know, this isn't a solution, this is an issue where we have problems. At ICANN, there is a convergence of the technical people who have long dominated ICANN discussion, the IP lawyers who have their own vocabulary, and the new kids on the block are folks who are interested in data protection. The engineers talk about use cases. I talk about purpose of processing. And sometimes these things, we talk past each other again and again and again, because neither side wants to really understand how the others use the words. It's fascinating from an academic perspective, possibly not helpful in terms of wrapping up these committees. Next slide, please. Consent, of course, has been seen forever as the way around data protection rules. Just get the end user to consent. I did it when I logged on to the platform today. I have no idea what the big blue button has in its privacy policy, but I didn't log on early enough to read all those documents. So my consent is rather bogus. We've had issues about this as privacy protection people for ever since data protection law came into being. The GDPR has once again focused in and refined what you can consent to, and the purposes are multivalent as opposed to one or the other. Pick a thing doesn't really work anymore. You can't get people to consent to things that are basically a violation of their fundamental rights. So that's an improvement. We will see litigation and court cases that will refine these things. I have been arguing since the get-go that the DNS business is arcane. I'm sorry I can, folks, but nobody else cares about this stuff but you. And I could prove that if I did an ethnographic study. The folks that are here are folks that have been here forever. It's not like this is a big public arena.
Mhm.
The individuals who have domain names can't comprehend the possible data flows and third-party access. They have no idea that Reuters has their data. Consent is for all aspects of the RDS requirements, including data retention. So you might be concerned if you're a Chinese dissident resident in Canada, second or third generation, but your data is in China, you might be concerned about that. You'd be right to be concerned. I hate to pick on a country, but I have to have real examples here. The withdrawal of consent is meaningless because of the value-added services. You keep your domains basically forever, unless you're a domainer and you're selling, but most of us get a domain and you have them for 20 years. Withdrawal of consent is meaningless because it's already been gathered up by the value-added services. There are layers of resellers, as I explained. And one question about whether certain principles that we came up with would be defensible is if we had oversight of ICANN. Because I would argue that ICANN is not a multi-stakeholder forum in terms of oversight. There are certain prevailing interests that rule the day. If you had an independent digital data trust, and we've done some research on this at U of T and with my colleagues at CIPIC and the Canadian Civil Liberties Association, if you had an independent digital data trust that had independent outsiders, data protection commissioners, authorities in certain fields like, say, banking, say, entertainment, you do your best to make it representative, but possibly not the same people that have been working at ICANN forever. Then you could perhaps more accurately determine what was in the public interest. Next slide.
I think Bill
Stephanie.
had a question. Go ahead, Bill.
Sure. I'm on the last slide anyway, so let's just wrap it up and take questions.
Yeah. I'm not a lawyer, but my understanding is that under US law, whether consent is held to have been given depends on whether you actually read the statement of what it was you were agreeing to. If you get into court and the attorney says, "Did you read it?" and you say yes, then yeah, you consented. But if you say, "No, I never read that stuff," then quite possibly the court will decide you didn't give consent, regardless of whether you check the box that says you did. So things are a little, can be a little chancy under US law. I have no idea what anybody else's legal system says, but even consent is not necessarily a get out of jail free card for whoever's running the website. Thank you.
Thank you. And certainly there has been a huge outlay of legal opinion and cases on these, contracts of adhesion. I mean, can I understand a 75-page contract that Apple makes me read? I mean, they can put in a requirement for me to scroll through everything and tick the box at the end, but do I understand it? Is it admissible? The privacy, very interesting organization in Southern California. Oh God, I'm going to forget her name, but the principal was Beth Givens. They sponsored research way back when the Gramm-Leach-Bliley requirements came in for disclosure of your financial stuff. And they did a readability study and found that for most of the, I forget the precise statistic, but it was the overwhelming majority of those disclosure statements that the banks had to send out annually to their customers, you had to have a master's degree to read them. Well, that's not acceptable and won't hold up in court. And I would argue that most of the technical things that you have to agree to, including the famous Apple one, you can't manage. And we have an aging population in most Western democracies. So I can tell you right now that I don't have the patience at my age to read something I had the patience to read 30 years ago. So there's a question as to whether you can force people to consent to stuff they don't understand. And there is no, I mean, I moan about this every time I look at my increasingly convincing pitches. Did I really get a package that is waiting for me to pick it up, or it'll be sent back? I mean, I am aware that you don't click things, but I've been working in this field for, let's see now, 1984 was when I started. I'm pretty aware of things, but I still get tech fatigue. So, and most people in the public have a bad case of tech fatigue. And quite frankly, I make it my business to cross-examine so-called digital natives to see what they understand. They're not any more aware of how to protect their fundamental rights. They may have more familiarity with the platforms and how they work, but I'm not sure that they're protecting their fundamental rights any better. And as I say, the cybercrime scammers are getting better and better. So these are very difficult problems that the kind of polarized debate that has gone on and hasn't been helpful. I mean, I think some of us really, really understand how difficult this is. We need a very nuanced discussion, and we need to split everything out into the various component elements. What can we fix? What can we do better? Can we tease this apart and do some things centrally and take the burden off our contracted parties and off our registrants? That to me is the question.
Bill, follow up on that?
No, I don't think so.
Okay.
I will say, since we're down at the end, that I've been involved in a working group at ICANN for some time, and the ICANN non-disparagement standard prevents me from naming names, but I've been dealing with several people from the contracted parties,
right,
most of whom have been working in good faith, and one of whom has, in my view, been working in massive bad faith the whole time. And that, I have to confess, prejudices me when anyone says, well, the contracted parties have a problem, they're trying really hard. Maybe they are, but personal experience is coloring my view. Thank you.
Well, I'd love to chat with you offline. I can only tell from, who I'm dealing with on our working groups and whether they are, I basically evaluate as to whether or not they're, in my view, following data protection law and advancing arguments that are sound. And that's what I find, I've been very impressed. They've gone from really not having too many people who understood data protection law when I started here in 2013 to having pretty expert people there. And I was thrilled when, I think I can say something nice about someone. I can't say anything bad, but when Thomas Richter released that basic compendium, forget the name of it, but it was released back in 2018. That was the first time I had decent data diagrams, and I had already defended my doctorate. I had gone through all the ICANN records. The sketchiness of the basic facts of where the data was going, a data flow map. I mean, the agency that I worked for in Ottawa, one of the central agencies, you know, there's a data flow map around the central elevator wall, you know, like you have to be transparent about what's happening with the data. And ICANN hasn't been. Like, fine if you were in there and understood it, but for a scholar coming in, good luck to you. And a lot of those documents aren't available anymore. I have saved them for the purposes of backing up my dissertation, but I mean, you shouldn't have to do that. I have told them for years, get a librarian or two and an archivist and maintain these basic public records better than you're doing right now. I mean, they've tried, but you know, it's not up to staff to manage records management. It's up to ICANN to recognize that they have a public responsibility. Anyway, rant, as you can tell. But yeah, I'd love to talk to you about who you think's acting in bad faith, because we can be led down a garden path if we don't have the facts. And if you don't work in this area, you have to take the testimony on faith. Like I remember reacting when one of the intellectual property folks felt that the registrars should pay for the costs of serving documents to their privacy proxy customers. Now, I find that a little bit much. You can't get anybody to cover the costs of serving documents. Serving documents in real life is expensive, difficult. You have to hire somebody to go knock on their door and serve it. The mere fact that we have permitted the privacy proxy service policy to put one more barrier between you and the individual doesn't mean that when you get the address, you can force the other guy to pay the costs. So I can spot that as a gambit, but I can't spot necessarily someone who knows the insider economics and is acting in bad faith. And so that makes us a little paranoid sometimes.
Did you want to say anything about the slide that's on or right now?
Well, you know, one of the prevailing problems that I see in this fight about trying to maintain the registered name holders' rights is that an awful lot of small organizations and individuals have flocked to the platforms because it's easier. I myself don't maintain my website. I hate it. It's not something I like doing. It's you don't want to know how old my website is. I haven't listed links to all my recent research. It's terrible. I sympathize with them. However, the moment you go on a platform, you're putting your customers, your readers, your constituents, all in the hands of the intermediaries, and they're not necessarily looking after the best interest, naming no name. So this is a fundamental, you know, those guys are well represented at ICANN. They don't care about selling domain names. They care about having it so difficult or so expensive that people flock to their platforms. And that's a problem because once again, I can't protect the end user's rights and human rights if there's a giant company that purports to be doing that and isn't. So that's a question of where does the public interest lie in data protection, in platforms. From a government perspective, platforms are attractive. They can lean on those companies, not very successfully, one would argue. One would, you know, a lot of discussion nowadays about how the platforms are bigger than the governments. And that is the case, certainly in terms of profits. which, you know, just gets you back up to the first question. Will differing approaches in the different countries fracture the internet? I leave you to talk to Milton Mueller about that one. He's been writing on that whole issue a lot. And how can civil society be most effective in this environment? Well, I think, you know, continuing along the role of following the human rights issues. I didn't talk about some of the work that's going on in human rights and artificial intelligence, but the Council of Europe recently commissioned a big study / initiative on human rights impact assessment for AI. And if you Google that up and go to the Council of Europe website, you will find this document. It's kind of the go-to for human rights impact assessment. It's quite complex. I think it's more than ICANN needs, but ICANN said it would do human rights impact assessment, but is not doing it on the stuff that really counts. And the stuff that really counts would be the entire iceberg of the registration data, in my view. So including the stuff below the water, which they don't have authority on, but they could pass over to the registrars as best practice. You know, that's an impact assessment those guys ought to be doing. Anyway, any other questions?
Okay, I will stop sharing, and
I can send you the link to that human rights impact assessment.
that would be great. Bill, Alfredo, if you want to turn on your video, and Alfredo, do you have something to say?
Well, basically, I just want to thank Stephanie for an insightful overview of different actors, and especially how ICANN is dealing with privacy data, protection data, and human rights in a way. And I would actually encourage everyone to dig into the material we have in the complementary resources in the different modules, because we touch upon that data protection. We talk about privacy issues, and actually Stephanie just gave a great overview from the beginning of ICANN, and even the internet, if we look at it closely, of how this has been evolving and how are different groups dealing with reaching consensus on sort of a geopolitical international way of dealing with data privacy and human rights. I don't see any solution, but if we keep on with the conversation, at some point we should reach some kind of consensus that most, and I repeat, most governments and most constituencies will agree on. So that's my take. Back to you, Glenn.
Yeah, okay, I'm gonna let Bill, any final comments?
Yeah, I would say that I'm not sure whether continuing the conversation will get us to consensus, but I'm absolutely certain that failing to continue the conversation will keep us from getting there. So it's a one-way bet, I think. Stephanie, you asked earlier, you said something earlier about talking offline about what my particular ICANN experiences have been. I'm happy to do that. Glenn can get you my email address or whatever. I'm not sure whether I'll be talking or ranting, but
I'm always happy to listen to a rant. And I should have said right off the bat, and I'll say it now, I'm not a lawyer, I'm a policy person.
Right.
Now,
Right.
so any comments that I make about the legality of various things, mind you, I have to say I'm batting whatever 100% is in batting language. I'm not a sports person either. So far, every legal opinion that we've sought has backed up what I've been saying. So I feel pretty smug. But I think, Bill, the important thing is people have to recognize that democracy is a long, never-ending dialogue.
And messy.
And it's messy. And oh my God, take a look at the shots of what's going on Canada's Parliament Hill right now. I'm a little shocked. We're all a little shocked that the chasm between the two sides on something as basic as vaccination can be so big. And the mistreatment of people can slide through this chasm. It's shocking. Speaks to continuous dialogue, you know, painful. So happy to hear you, Ren.
Okay.
Great, guys. I think we and it's been fantastic, Stephanie. I was wrapped, you know, I thought it was a lot of minutia, but it was great because it all fit together. It actually answered a lot of the questions that was in my mind that I did not understand on this issue, because unless it's like yourself or people like Alan Greenberg or a few others within at large, they're deep in the weeds. But generally speaking, the majority of us are pretty, you know, marginal on this topic. But I think you brought in a bunch of stuff that I can well appreciate. So I think it was you know, at first when we said, let's talk about WHOIS and human rights, sort of, you said, well, maybe it fits in with other actors or other things, but I think it's been well suited in what this discussion is today. So thank you so much for entertaining us today. The recording will be saved, it'll be shared, and I'll send you the link as well. So any final comments, Stephanie?
No, it was a pleasure to do this anytime. I always ready to talk about privacy at ICANN.
You're great at parties, I guess, right?
Oh, yeah, right. Well, invite me all the time.
Thanks again, everybody. This concludes the meeting, and I'll make the connection with Bill and Stephanie. And thanks everybody for joining us today. Thank you again. And thanks sorry about all this problems with our other platform, but I think we managed it. Thank you again.
Very good. Thank you.
Thank you. Bye-bye.